Good afternoon, everyone. Thanks very much for coming to this event, which has been organised by Garden Court's housing team. My name's Franck Magennis. I'll be chairing tonight's discussion. We're going to hear from two barristers, Catherine O'Donnell and Adrian Marshall-Williams. Illegal evictions have continued during the pandemic as landlords look to get around the government's restrictions to protect renters, and increased minimum notice periods for ending tenancies mean those who have struggled to pay their rent may be more at risk from illegal eviction than before. This seminar will provide an update on the basis of and procedure to follow for illegal eviction claims, regaining entry, and obtaining damages, and is for practitioners who represent tenants. I have some meeting instructions to relay to attendees. Firstly, you've been placed on mute. Please post your questions in the Q&A window. The chat function is enabled for any other comments, queries, or feedback. Please do not post questions in the chat function. Secondly, resources will be circulated to registered delegates after the webinar. Thirdly, this webinar is being recorded. Now, what that means is that audio and video of the panelists and anyone who speaks, if they are unmuted, will be recorded. This webinar may be shared on our marketing channels, including our website and social media. And finally, please refer to the instructions which have been posted in the chat window if you're experiencing technical difficulties. Let me now pass over to you, Catherine.
Thank you, Frank, and welcome to everybody for coming along to the seminar today. The first part, my part of the seminar, is going to consider the civil claims associated with unlawful evictions. There are obviously criminal sanctions, but unfortunately, as we know, the police rarely take criminal proceedings in these circumstances. And if they are called to an unlawful eviction, which some of our clients do call the police, then they're usually told it's a civil matter and they don't become involved. However, before I move on to consider these civil matters, I think it's worth if the police have been involved, I'd just like to say it's worth engaging with them as the advisor and representative of the client, because often there is useful evidence to be had from the police. There are usually recordings of the client if they phoned and what they've complained of at the time, particularly if the events are disputed by the landlord, which they usually are. There might be police call logs, which also record the events, and there might well be office recordings or notes taken by officers at the scene. So it is useful to engage with the police, even if they haven't been particularly helpful to the client at the time. They could be thereafter. And in that vein, you may also want to contact a tenancy relations officer who's often been contacted at the time. So that's what my session is going to be about. Amy, I don't know if is going to be dealing with my slides. I wonder, Amy, if you're able to share my slides. Great. So yes, if you go back, this is the first, and the next slide, please, sorry. So the term unlawfully, go back, I'm sorry about this. Yes, there we are, great. So the term unlawful eviction isn't precisely defined in civil law, but when we talk about unlawful evictions, what really this is, it's an umbrella expression for what is likely to be a number of unlawful acts committed by the landlord or someone acting with them or on their behalf, which excludes the occupier from residential property that they have a continuing right to occupy. As we know, the circumstances of unlawful eviction differ widely, and so it's crucial before embarking upon a claim for unlawful eviction or even pre-action correspondence to consider carefully the client's entitlement to occupy the premises, the circumstances surrounding the eviction, both before during and afterwards, because before there may be events before the eviction which constitute a cause of action separate to the actual eviction itself, and events which happened afterwards, after the eviction, may give rise to further causes of action. So it's important to consider carefully what causes of action you have and against whom, because there is often a number potentially of people involved in the acts which are complained of, who may be possible to claim against separately. And also to consider, particularly I think in relation to the actual eviction itself or the exclusion, whether there are any potential defences. So can you go to the next slide, Amy, please? As I've said, there are various causes of action which are available depending on the circumstances and types of occupation. So what I'm going to do is go through what I consider to be the main causes of action and the types of cases that we usually deal with. So I'm going to be looking at the basis of claim, I'm going to be looking at the parties, and if potentially relevant defences. So starting with the one that we usually start with, which is a breach of contract. The contractual term that we're concerned with is usually the covenant of quiet enjoyment. And as you'll know, each tenancy agreement has, either by an express term or implied into it, obviously, you know, if there isn't anything written in the contract, or you don't have a copy of the contract, you can certainly, the law implies into it, an obligation on the landlord to allow the tenant possession of the property demised without interference. So that is essentially what is known as the covenant for quiet enjoyment. It doesn't have anything to do with being quiet necessarily or enjoying the premises. Its definition is in Kenny and Preen, one of the main cases in this area, in that the term refers to the exercise and use of the right of possession and having the full benefit of it, rather than deriving pleasure from it. So you as a tenant have exclusive possession, or you have some other limited possession of the property, and you have a right to that possession, and the landlord should not interfere with that possession. Can you have the next slide, please, Amy? The interference must also be substantial. Obviously, if you are being excluded from the property, then that is as substantial interference as you can get. As I say, the obvious example of breach in the context of unlawful eviction is excluding the occupier by changing the locks, and that's usually what has happened when the client comes to see an advisor. But it can also be harassment short of outright eviction, so it's something designed to force a tenant out, such as persistent threats or the cutting off of utilities. That in itself is a breach of quiet enjoyment, even if the tenant hasn't been excluded from the property. And I give you some authorities there for those principles. It's important to remember, because this is often the way in which the landlords seek to justify what they've done to themselves, and they may even believe that they're entitled to do it. The right is not conditional. It is not a conditional right. You have the right to quiet enjoyment as long as you are in possession of your right of occupation is still in play. Often, if rent payments haven't been made, the landlord will consider themselves within their rights to exclude the tenant. And sometimes this notion may come from the fact that tenancy agreements often have a term in them which purports to make the covenant for quiet enjoyment conditional. So I've seen, for example, tenancy agreements, I'm sure you have, which say the landlord agrees with the tenant as follows: that the tenant paying the rent and performing the agreements on on the part of the tenant may quietly possess and enjoy the property during the tenancy without any lawful interruption from the landlord. So there seems to be a link there between the obligations of the tenant and the quiet enjoyment afforded by the landlord, but they are not connected. They're not interconnected in that way. Also, the right begins on the date the tenancy begins, not upon entry into the property. So they don't necessarily have to be moved in yet in order to be excluded if they're breach of the right to quiet enjoyment. And obviously ceases upon termination of the tenancy. Can I have the next slide, please? So who can claim and against whom? This is one of the most straightforward ones. So the tenant against their landlord. This is a contractual claim, so it's between the parties to the contract. One of the issues that often comes up is who is the landlord? Who are you contracting with? It is Sections 1 and 2 of the Landlord and Tenant Act 1985 can be helpful in this regard if you don't know. Under Section 1 of that Act, if a tenant makes a written request for a landlord's name and address to any person who demands or is the last person to receive the rent or anyone acting as agent for the landlord, they must supply the name and address within 21 days or they're guilty of an offence if they fail to comply without reasonable excuse. And under Section 2, if they're told that the landlord is a company, then you can make a further request of the landlord or the person who demands rent or the landlord's agent for the name and address of every director and secretary of the landlord company. And again, it's an offence to fail to comply. But there is authority for the fact that if the landlord's identity is unknown and they have acted through the agents, and then the agent can be sued. What can be claimed? You can get an injunction and special damages. The authority for that is Branchett and Beanie, and I know that Adrian's going to be discussing damages later, so I won't say any more on that. How about licenses, which are also contracts? Well, it's been said that a similar right to quiet enjoyment, albeit not a covenant, may be implied into a license agreement, and there is the authority for that is Smith and Nottinghamshire County Council. However, that was student accommodation, and it wasn't an exclusion that was an issue in the case. It's more the wider circumstances of quiet enjoyment. So therefore, protection from eviction for licensees is generally covered by the Protection from Eviction Act, which I'm going to talk about in a moment. However, it's also important to remember that even excluded licenses, and we'll look at excluded licenses later, are entitled to a notice in their agreement or to reasonable notice. And the authority of that is Gibson and Douglas. So moving on to the next slide, I'm looking at defences in breach of contract. As I said, the claim can only be brought with a subsisting right to occupy. The situation may arise, therefore, and sometimes does, where the landlord claims the tenant has surrendered the property and therefore has no subsisting right to occupy. So this is something which may well come up and does come up in cases. So what is surrender and what is an effective surrender? Well, there's surrender by deed, and this is a written agreement by which the parties agree the tenancy will end. And clearly, if you've got that in a case, then you're going to say, well, there isn't any hope of bringing a case of breach of contract. What usually happens is defendants are more often relying on what's called surrender by operation of law, where conduct by one party is inconsistent with the continuation of the tenancy and which the other party can be seen to have agreed to. So there can be circumstances by which the tenant acts inconsistently with the continuation of the tenancy, and it's with the agreement of the landlord, but it must be clear and unequivocal. For example, giving the keys back and saying, I'm going now, here are the keys, whatever stuff in there, you just have to deal with yourself. Obviously, it's a matter of evidence, but that would be a kind of a clear and unequivocal surrender of the tenancy. But it's also important to remember that whether a joint tenants, all tenants must be party to surrender. So that's a safeguard there where there's more than one tenant. What is not surrender? Well, it's not going to be an indication from your client that they're going to leave, that they're looking for other accommodation. They may even be absent during this time, but their possessions or some of their possessions have been left at the property, and certainly they're then continuing to pay the rent. The fact that the landlord has chosen to believe for their own purposes that they're no longer there, and therefore they can take over possession, well, that is unlikely to succeed. But obviously there are lots of grey areas and all sorts of circumstances you'll come across, so it's important to consider. But generally I would say that proving surrender is with equivocal circumstances going to be very difficult for a landlord. It may, however, potentially impact upon damages, because obviously if somebody has got somewhere else to live and they're living somewhere else or what have you, then obviously any distress and inconvenience might be reduced by that. Could I have the next slide, please, Amy? So just moving on to the Protection from Eviction Act. Under Section 3 of the Protection from Eviction Act, it's unlawful for an owner of residential property to recover possession against occupiers of residential property after the end of the tenancy or licence, otherwise than by proceedings in court. So who can claim and against whom? Who can claim is subject to lots of exceptions and lots of interpretation and different interpretations. The claim can be made generally as a prerequisite by a person occupying the premises as a residence. And it's generally referred to as lawful occupation, which means, and in the Act, Section 1.1, that refers to by contract, enactment or rule of law, giving them the right to remain in occupation. It also applies only to premises which are let as a dwelling. And there is authority that even a room without cooking facilities, as long as it's occupied as a residence or home, can be deemed to be let as a dwelling, and that's the case of Eurotemp Ventures versus Collins. There is, however, much more difficulty among licensees of temporary accommodation under the Housing Act, which has been held not to be occupied as a dwelling. I'm afraid I haven't given you the correct reference in relation to RCN, and I'll correct that in relation when the slides go out. But essentially, as I say, licensees of temporary accommodation under the Housing Act have been held not to be occupying them as a dwelling. It's a complicated area, this, and we can't really go into it here, but often these issues arise during homelessness cases, may come to you as a homelessness case. When something goes wrong in the temporary accommodation that's been provided to the client under homelessness provisions and they're asked to leave. Or there may be an issue when initially someone was provided with temporary accommodation and they remain there when their Section 193 duty is accepted. And there may be issues there about whether or not they are then occupying premises which are let as a dwelling. And there may also be issues about who is the landlord if the local authority is using accommodation which it is leasing from others, even on a temporary basis, to house homeless applicants. So as you can see, it's a complex area, lots of different factual situations, and if you're in any doubt about that, or even want confirmation of what you feel strongly is the case, then I would definitely say that you should get advice from counsel. Next slide, please, Amy. So, as I said, there are a huge amount of exclusions on the Protection from Eviction Act. Provisions don't apply to statutorily protected tenancies, which are defined in Section 8, and which include, among other things, protected tenants under the Rent Act 1977, assured tenants and assured short-hold tenants. Obviously, they have protections elsewhere. Neither do the provisions apply to excluded tenancies and licenses, which is has evolved over the years and is now quite extensive, and it includes those who share with a resident landlord or with a member of a resident landlord's family, those in holiday accommodation, those who have licenses granted other than the money on money's worth, accommodation given under Part 6 of the Immigration and Asylum Act 99, those with a licence at a public sector hostel, and also those disqualified due to their immigration status from occupying under a residential tenancy agreement. The claim is against the owner, as defined in the Act as the person who, as against the occupier, is entitled to possession. If eviction is carried out by somebody else, you will need to show they're acting on the owner's behalf, which is obviously an evidential issue. And the claim is for damages under the breach of statutory duty or an injunction. Can I have the next slide, please, Amy? I then want to move on now to look at associated claims. As I said, it's unusual for unlawful evictions to involve, it is usual, sorry, for unlawful evictions to involve associated torts, either common law or under statute, and it's important to consider and claim these where applicable, alongside the breach of contract claims, so that a general, aggravated and exemplary damages may be sought. So as I said, you need to be specific about your cause of action. There are different types of tort, and the most common one that we come across is trespass, because they're often necessarily involved in, well, they are necessarily involved, at least trespass to land, usually in the eviction itself, the actual act of exclusionary act of keeping somebody from their property. So the first of those, trespass to land. This is where the landlord or the agent enters or remains on the property without permission, and that this will usually be them, at the very least, coming in to change the locks, to make sure you're not there. To first of all, to go in uninvited, to make sure you're not there, and then to change the locks. And that's probably the least that they will do. So who can you claim against? Who can claim, sorry, and against whom? The tenant whose right to occupy has not come to an end, against whoever unlawfully enters, and the landlord, if it was not them, but the person who is acting on the behalf. So, for example, if they send an agent in to do it, you can claim against the agent, and you can claim against the landlord if they were doing it on behalf of if the agent was doing it on their behalf. For licensees, it's trickier because they're usually licensees don't have exclusive possession, so you can't claim, but look at the license contract and see, make sure of that. And what can you claim for? You can claim for damages and or an injunction to prevent further trespass. Next slide, please, Amy. Then also another scenario, of course, is apart from changing the locks, they've bagged up or not even bothered to put in bags the claimant's possessions, and they've removed them from the property, either taking them and putting them on the street, outside the front of the house, front of the flat, or even taking them away. So what's available to you there is trespass to goods or conversion. Trespass to goods is a direct interference with another's belongings, such as I said, putting them outside. But if the goods are taken and not returned, this is conversion. Under the Torts Interference with Goods Act 1977, there's also the statutory tort of wrongful interference with goods, which kind of is complementary. Who can claim and against whom? Well, obviously the person who owns the goods. It's not dependent upon a right of residence. However, of course, the claim that you're bringing is likely to be the tenant, because that who will be your client, and the claim is against whoever interferes with the goods or converts the goods. And the landlord, again, and also the landlord, if it wasn't them who did the act, but the person was acting on their behalf. You may also come across kind of what they believe some landlords to be some kind of a defence, is that they will retain the goods until any rent owed is paying, but that's not permissible. They can't kind of essentially hold the goods hostage until the rent is paid. That isn't a defence. And you have a claim for damages and or for return of the goods. So there may be damages in the sense that the goods have been destroyed, but even before then, if they've been retained during and they haven't been returned, and during that period, even though you've asked for their return, you've had to buy replacement goods, then obviously there might be damages for that. Could I have the next? Please. There's obviously also trespass to the person in some particularly bad circumstances. You know, we've read these cases where people have, either the landlord has gone along or a group of people on their behalf, and they've assaulted the tenant, maybe even their family, or they've threatened them with assault. Those would be torts of trespass to the person, which are essentially a general term for two types of tort, which is battery, in the intentional application of direct physical force without reasonable excuse, or assault, any acts which puts another person in immediate or reasonable fear of battery. Who can claim? Again, you'll be acting for the tenant, but actually whoever the victim of the assault, whoever is the victim of the assault can claim, as it's not specifically dependent upon the right of residence. And they can claim again against whoever commits the assault or battery, and the landlord if the person who committed that was acting on their behalf. And the next slide, please, Amy. Interesting point to note, you may come across is where the tortfeasor is a company. So, for example, you've got agents. Either the landlord itself is the company or the agents of the company, and even the landlord in their corporate capacity or the agent, acting in their corporate capacity, directors of those companies actually commit the tort, because obviously the company itself isn't going to put the bags on the street. If it's a director who does that, then they are joint tortfeasors with the company. You can't hide behind the shield of incorporation if you are committing a tort, because essentially as a director you're only authorised to do acts, which are as part of that directorship for the company, which are not unlawful acts, such as these torts. And it's useful to consider this, because what sometimes happens, and I've certainly found this in the past, is that you have people who, companies who may be either acting as agents or as landlords, or people who have set themselves up as a company in order to do that. And then essentially the company is not worth anything. By the time this has all happened, you've come to court, or even by the time the client comes to you, they've set themselves up in another company, or they're no longer trading, or they're in liquidation. But the director may have assets. And going back to Section 1 of the Landlord and Tenant Act, Section 2, you might be able to find out about who their directors were and their addresses. Obviously, you have to be careful if the person you're claiming against has filed for bankruptcy, because you won't be able to bring a claim on it without permission of the court. Can I have the next slide, please, Amy? Just quickly, Section 27 of the Housing Act. This provides a statutory cause of action for damages where a landlord unlawfully deprived the residential occupier of his occupation of the whole or part of the premises, or attempts unlawfully to deprive the residential occupier of his occupation of the whole or part of the premises, or, and this is the mouthful, knowing or having reasonable cause to believe the conduct is likely to cause the residential occupier of any premises to give up his occupation of the premises or a part of them, or to refrain from exercising any right or pursuing any remedy in respect of the premises or any part of them, does acts likely to interfere with the peace or comfort of a residential occupier or member of his household, or persistently withdraws or withholds services reasonably required for the occupation of the premises of the residence, and as a result of all that, the residential occupier gives up his occupation of the premises. So that is the statutory cause of action. Can I have the next slide, Amy? Just to explain that this provision was introduced in 1988 to discourage landlords from unlawfully evicting Rent Act tenants in order to take advantage of the 1988 Act's introduction of assured tenancies, which would be at higher rents because they wouldn't have the Rent Act protection anymore. So that's why it was specifically brought in then. Who can claim against whom? The claim can be brought by a residential occupier as defined by Section 1.1 of the Protection from Eviction Act. It relies on those provisions, except those excluded by Section 3A of that Act, which are excluded tenancies and licenses, which I dealt with above. The claim is only against the landlord, even if the agents carried out the relevant acts. The landlord is the one you claim against. So you're not, like the torts, claiming against the person who committed the act as well as the landlord. You can claim damages only. Expert evidence will be needed for the calculation of the loss of value of the landlord's interest, and Adrian will refer to that later. Due to the ease with which assured short-term tenants can be evicted, however, this has been most relevant to secure assured and Rent Act tenants in the past. Can I have the next slide, please, Amy? There are defences within the Act itself. It's a defence if the landlord believed or had reasonable cause to believe that the residential occupier had ceased to reside in the premises at the relevant time, or they had reasonable grounds for the acts complained of. There's also no liability if the occupier is reinstated before proceedings are disposed of. So these are kind of final when there is no, you're not seeking re-entry under this act. The damages can only be awarded if it's a final eviction. So what that means is that if a successful application for re-entry is made at the same time under a claim for breach of contract, or reinstatement is offered by the landlord and the client accepted, then you can't get damages under this act, but you may have damages for the other causes of action, which you might have been claiming for the torts specifically. Can I have the next slide, please? This is the final slide. Just want to mention a couple of things that you might always want to consider in the circumstance of the claim that you're making. There's obviously the Protection from Harassment Act. You may want to rely on this because there may have been harassment, a course of conduct prior to the eviction, which you want to claim damages for. You also may want, if the tenant is readmitted, an injunction to stop the landlord repeating that behaviour. This usually happens when you're going for an injunction. The client's been forced out, but you've got an injunction quickly to get them back in. You'll be usually looking to protect the client when they go back. You also may have some remedies available to you under tenancy deposit legislation. The client, usually these landlords are not the kind of ones who bother with the rules. So it may well be likely they took a deposit and then never registered it or protected it and never gave them information. And finally, I just wanted to mention about warrants which have been unlawfully obtained, specifically because of the case of AA versus the London Borough of Southwark. You may remember this case quite a while ago now. There was a High Court case where a landlord needs permission to obtain a warrant for possession. For example, in this case, the original possession order is more than 6 years old, but obtains an executive warrant without such permission. This can be an abusive process, and in that case, the eviction was unlawful. Certainly, that was the finding in A and A, but the facts, I flag it up because it's there. The facts, however, are quite extreme, as anybody who's aware of the case will know. The court found in a very damning and very long judgment against the local authority that local authority staff had been involved in a tortious conspiracy to evict. And so it was very much in the context of those circumstances. I'm not saying that it can't happen again in other circumstances, that an unlawfully obtained warrant would give rise to a claim for unlawful damages for unlawful eviction, but I'm not aware of any other claim where that's succeeded. So that is my run through of some of the main claims that you may want to bring. Then there are others, I haven't included them all, some other ones which I don't consider as important, but that's it. And now Adrian's going to speak about damages.
Brilliant, thanks Catherine. Adrian, over to you.
So good evening, I'm just going to put my screen onto sharing screen, and then I hope that should mean that you're able to see my slides. Let's just get that. Okay, so I'm going to talk about procedure, and although it says damages there, I'm going to mention briefly other remedies because they are important to damages. I've started very much at the beginning when a client comes in. Now, I do realise that I'm speaking to an audience of very experienced people and that this is what you do day to day. But I'm just trying to give you a perspective on sort of some of the things which I have seen in cases which have given rise to problems. And I say this in the context that I know that what you're often presented is a very confused picture with different people involved doing different things. And that's why I put down these very basic things which I think are important, which is to identify what the legal interest is. I say that because I still see lots of agreements which say they are licenses, but when you look at them, seem very likely to give exclusive possession for a term and therefore be tenancies. Very important to consider the potential parties for the very simple reason that it is bluntly much easier to bring somebody in later if they need to be a part of a claim than it is to deal with the situation where you have joined somebody who you really don't have a claim against, and then you have the situation of their costs when you need to try and get them out of the claim. So what I put there is that it is sensible to identify separately in relation to any particular potential party what the cause of action any claimant would have is against that person and why they should then be included. And I would also strongly recommend, and I'm sure many of you do this, but where you have the time, do the kind of internet research that can just back the things up, because you can, for example, find out information about directors of companies through Companies House. You can check the bankruptcy register online, and you can get often there will now be interesting pieces of information available on things like local authority licensing registers. So I would encourage doing that. Clearly, as soon as you can, you're likely to be contacting the landlord or the agent, or the person whose details you have, to try and in most circumstances get either stop an unlawful eviction happening or get your client back in. I've just repeated some basic things here again, because this is just my experience of what can lead to problems. So the bottom line: be clear about what you're asking somebody to do. You need to set a clear deadline so that you can then go on to the next stage. Often those deadlines will be short because it's urgent. It's good to explain why. I would strongly recommend that your letter does explain what the causes of action are, so that if that needs to be read later by either an advisor for them or a judge, it can be seen that you had clarified the basis of your claim, and you put it in that letter. And also be clear about what will happen if they don't do what you ask for, which obviously in many cases like this will be that you'll be proceeding to seek an interim injunction. And as soon as possible, ask for information, set it out in detail, so that when you then need to follow it up, if it isn't given, you can refer back to that first request. I set out here, and this will come to you, the sort of relevant provisions. There is no pre-action protocol relating to unlawful eviction claims, as I'm sure you're aware, but we should have in mind the practice direction on pre-action conduct. That's obviously available on the internet. This is the standard for all types of cases, and the first step that it suggests is that you need to write to a claimant with details of a claim. It then suggests a response by a defendant within a reasonable time, and suggests 14 days. Clearly, it would be very unlikely in most unlawful eviction cases for us to be giving 14 days to respond. But the point is that we need to be able to explain why we're departing from that, why it needs a shorter period, whether that's 1 day, 2 days, or whatever it is. But we need to be clear that that's what would be expected to be normal, and our reasons for making it shorter are justified. It seems to be quite unlikely. So that refers to objectives here, which are the objectives of pre-action conduct. Again, these are things you're familiar with. You're supposed to exchange information, understand each other's position, and you clearly need to give an option that decides things without proceedings. What I would add at this point, in many of these types of cases where you're trying to get somebody back in or stop an eviction happening, your first letter may well be directed at that. And in terms of any damages claim that you want to put in, you ought to send a further letter that sets out the detail relating to that. So I'll go on to the next slide, which is presuming that is not successful. You're looking to apply for an interim injunction and issue a claim. Now, just in terms of the documents that are required, the application form, there's an N16A, which is a specific application form for an interim injunction, and is available on the website that I put there, which is the gov.uk website for county court forms. That is the form that the court and the judge will expect to see, and so is the form that you should use. I put a copy of it there, but I'm sure you're all familiar with it. You'll also need to do a witness statement, and you'll need a draft order. And I would also recommend that you are ready to serve a notice of issue of public funding, because the sooner, even if that doesn't have all the details, the sooner that it is served, the better, and the more difficult it is for any other party to complain about not having knowledge of that. A reminder that you also need the fee for issue of an application and, for the claim, the figures for that can be calculated. There is a leaflet which sets out the current ones, which is called EX50. And you obviously need to calculate the application costs £255. The issue fee depends on the value of the claim, which you'll need to put in the claim form. So moving forward to the witness statement, I've referred there to Practice Direction 25A, paragraphs 3.2 to 3.4. Those are the rules which set out what a witness statement for an interim injunction should cover. The most, probably, which is obviously an explanation of the fact, the most important thing in that, though, to bear in mind is your duty to make full and frank disclosure of all matters relevant to the application. That means questions of fact and law which might go against you. That's directly part of the rule, and because it's set out at paragraph 3.3 of Practice Direction 25. But the point to bear in mind is that if you're advising a landlord who receives an interim injunction made without notice, the first thing that they will try to do is to consider if they can make an application for that to be discharged on the basis that you breached your duty of disclosure. So you don't want to do that. You want to make sure that your witness statement has covered that. The other things it needs to cover, apart from setting out, your client's interest and what your understanding of the claim and what the defendant's interests are and the claim you bring against them and why this fulfills an unlawful eviction, is an explanation of why it is made without formal notice. I'll go on to look at that in a minute. And if it's being made without telling the landlord at all, in other words, in secrecy, that will need a compelling justification, and that compelling justification will need to be set out in the witness statement. It's very unusual that you'd be doing that in an unlawful eviction case in these days, and the only likely scenario will be where you can clearly show that there's a risk that by telling the landlord that will lead to the property being relet. Also consider if there has been delay in making an injunction application, and that's not uncommon, a judge will want to hear an explanation of that. Perhaps I should also note, consider when you're preparing a witness statement, fundamentally the judge is going to be looking at the strength of your client's case. The stronger the case, the more satisfied the judge is always going to be about making an injunction, and the balance of convenience, the risk to both sides if an order's made or if it's not made. So anything that you have that by way of evidence that can be included in that, which will assist your case, you should include it. Now, if I go on to the injunction order itself, this is the N16 in standard form injunction, which can again be downloaded from the County Court Forms part of the gov.uk website. And there really is no reason not to use that these days, because it contains the right boxes for you to put in the provisions of the order that you want. It has the all-important penal notice, which you need so that you can enforce this as an injunction. And the final page, which is not included here, also includes an appropriate record of the hearing, which you also want to be filled in by a judge, so that has been properly done. I haven't sort of set out here standard kind of terms for injunctions, because it will depend on the circumstances of the case. If you are asking for somebody to be readmitted, then that would be, the order would be that somebody forthwith readmits the claimant to, and then you give the address of the premises. What I would want to point out, though, is that you often see orders which refer to not interfering with quiet enjoyment. that wording can be problematic, particularly where it's being suggested by a landlord that there isn't a term about that. And I would suggest taking care. In almost all cases, you will be talking about not trespassing to land, and it may be that is more useful. But you need to take care about the appropriate wording in an injunction in those circumstances. So there are two possible injunctions. A prohibitory injunction would be, for example, not to relet the property, or indeed not to trespass. But if we're talking about asking for a court to require a landlord to readmit a tenant, that is a mandatory injunction, and there often still seems to be confusion about what the appropriate test for a court is. So the slide there refers to the guidelines, which are usually referred to as coming from the case of Zockel and Mercury, although they actually go back to an earlier case. But the important point is, it's not the case that an injunction can only be given where you can show that there is a very high prospects of succeeding. The fundamental test is still what course of action involves the least risk of injustice if it is wrong. And it is simply the case that the stronger you can show your case is, then the less that risk will be. However, and so the court can be more easily satisfied about what the risk of injustice is. But even where you can't necessarily show that because there's an issue, you can nonetheless show by other evidence that the risk to you is greater by the injunction not being made. And so even without that, as it put a high degree of assurance, you can suggest that it is nonetheless appropriate for the court to make a mandatory data injunction, which will usually be in these types of cases to readmit the tenant. Looking at the order, the sort of other provisions of making an order, I've set out here paragraph 5.1 of Practice Direction 25, which applies to all orders for interim injunctions, and you do need to consider. The most important point about this is paragraph 5.11, which is the question of whether your client gives an undertaking to the court to pay any damages which the defendant sustains, and that can be any defendant you include, which the court considers that it should pay. That will usually arrive if the court at the end of the day decides that your client doesn't have the right which he or she asserted, and therefore the defendant suffered loss by injunction being made. You need to take instructions from the client about whether they will give that undertaking. You need to explain what it would mean and what circumstances the court might order damages to be paid on that undertaking. Even if your client says yes, you would still, in almost all circumstances, want to ask the court to dispense with it, because clearly if the court will dispense with it, that is in your client's interests. I'm in the situation of most of the clients that I'm dealing with, you would want to refer the court to the case of Allen and Jambo from 1980, which remains authority that it is wrong to deny an injunction to a legally aided applicant because their undertaking is not credible. In other words, they would not, they are not people with deep enough pockets to pay significant damages. Nonetheless, you be prepared for the fact that even if you make that submission, there may well be many judges, not depend on the circumstances, who will ask that your client does make that undertaking, which is why the instructions are needed. The other undertakings which may need to be given, depending on how far you get, are undertakings to serve, undertakings to file and pay the fees if the application notice has not been issued, or an undertaking to issue the claim itself and pay the fee for that. Those are obviously matters for you, but it's important that when you get to court, you are ready to do that. I'll move on to the question of notice, which I mentioned briefly earlier. So the first point is, what is formal notice? So for an interim injunction, formal notice means that serving a copy of the application notice with any evidence that supports it once it's been sealed, and that should be served 3 clear days before a hearing. So in other words, not including the day it's served and the day of the hearing. The rules permit you to the court to grant an interim remedy if that 3 days notice has not been given, but it must appear to the court there are good reasons for notice not being given. So the court has to have evidence, it has to address that, and it has to consider that. Anything which doesn't have that 3 days notice is informal notice. And in that case, you need to look at paragraph 23, Practice Direction 23A, paragraph 4.2, which says where an application notice should be served but there is not sufficient time, informal notification of the application should be given unless the circumstances require secrecy. And that is repeated in the Practice Direction 25A, which relates specifically to interim injunctions at paragraph 4.3. So informal notification, I would suggest, in this day and age, means that you have sent the application notice, the draft order, and the evidence. I would assume that in most circumstances you'd be wanting to do that by email, but it might be that you have done that by sort of messages on your phone or WhatsApp messages. It would also, I would also suggest that it now includes telling the other party of the proposed time of any hearing. Now, when you're making an interim injunction, you will need, from the point at which you know you're going to be making it, to be in contact with the court to work out the practicalities of how you're going to do that, because you are you will need to get the court to actually issue it and get you in front of a judge. That is going to require contact. There's a great variation about that, how that's been done between courts. It's obviously varied a lot during the pandemic as to how courts have dealt with it. So the earlier you do that, the better. But frequently, having had that contact with the court, you will be in a situation where you're told to present at a certain time, and the assumption is they will issue the application then. And once that is done, you'll be put in front of a judge, the first judge who's available to hear that, and that information should be given to the proposed defendant. Just before we sort of move on and dealing with that point, I would point out you can, of course, technically apply for an injunction without having to actually issue the proceedings at the same time, because you can give an undertaking to do that. In most circumstances, that would seem to be unlikely. The further time required to prepare the claim form is not great, and the court will almost certainly issue an application notice at the same time it issues proceedings. So it seems to me to be something which would happen pretty infrequently. I would just point out again, for the claim form, you want to download the latest edition from the County Court Forms website. It did change in October. You don't obviously need to put more than brief details of the claim, so that if you say that your claim involves damages and injunction in respect of an unlawful eviction of residential property, that's probably just about sufficient. But there is no reason not to mention other specific causes of action if you're doing that, whether that's trespass to land, trespass to goods, breach of covenant, or particularly if it involves breach of the Protection from Harassment Act. You will need a statement of value, and so when I come on later to look at damages, that will be helpful for you to calculate that, because you need that in order to work out the fee that what the statement of value is, and therefore the fee that you're going to need to pay. So assuming that you've made the application and the judge has indicated that an order will be made, the order must contain a return date. That's was in paragraph 5 of Practice Direction 25A. I would suggest that if you were offered a return date by telephone, it would in most circumstances make sense to resist that. You would mostly want to make sure that the defendant was under an obligation to attend court to respond to the undertaking. There also needs to be a record of hearing, particularly if it's made, if the landlord is not there. The N16 injunction order does have a record of hearing. You may need to ask the judge to make sure that has been completed. You will need to get the court to prepare the final order so that it's sealed quickly, and you may need to pay attention to that. It makes sense in any event to make your own record of hearing, because if the defendant receives an order and goes to solicitors, those solicitors may well ask for that record of hearing. So it makes sense to have a clear record of what information was put before the court and what was said. Service of the order, clearly that needs to be personal service, unless the landlord is in court and you get an order which dispenses with it. But it's much safer to use a process server who can achieve service of the order and then do what you also need, which is evidence of service of the order, because that is what you'll need both for a return date and if there's any question of enforcing it. So moving on to that return date, to prepare for that, you want to consider what are you asking for? Are you asking for the injunction to be continued in the same form or for it to be varied? Either way, you are likely to need to put evidence before the court explaining what you want and why you want it and the justification for that. Assuming that the court does continue an injunction, is it in the same form so that there is no need for further service if it's been varied at all, or if the date is being extended? There would need to be personal service or an order dispensing with that, which would be really only be appropriate if the respondent was in court and accepted that. But that's the matter which needs to be considered. Not infrequently, you come to a return date and the defendant has not complied with an injunction. Now, return date is separate from committal proceedings, but it's important to consider before the return date whether you are going to be wanting to pursue a committal application. You'll need to consider the funding for that and how you're going to do it, because it will make a difference to what, or at least it may make a difference to what further steps the court orders. So having made a decision, being clear about it, it is important by way of preparation. Particular claim, I would suggest that these, if you haven't been able to do this before, they should be served before return date. That really does make sense in order to take the case forward. But it's also appropriate to consider whether, if you've got further information, you have witness statements from a defendant, whether that means that you're going to need to amend the particular claim. If so, can you prepare them before return date, or do you need time to do that afterwards? If possible, I would suggest that you want to make directions as far, you want to have a court make directions as far as possible at a return date. That will advance your objective of getting the case going further forward. But in any event, you need to consider what's going to happen about those directions. My experience is that if the court simply relies on directions questionnaires being sent out, that can lead to problems. And it would be much better if you can't get directions at the hearing, for there at least to be an order for a case management hearing after a certain date. You may want to deal with the defence and reply before that directions hearing if that hasn't been done. But I would suggest that that is more likely to give you a concrete date where the case can be taken forward. I've just dealt with some issues arising in giving directions, because these are things which have been arisen with me recently. I've referred there to Rule 26.7.4, which provides that the court will not allocate a claim to a small claims track if it includes a claim by a tenant of residential premises for a remedy in respect of harassment or unlawful eviction. I saw only last week an attempt by a court to do that, so don't rely on the fact that it won't happen. But in reality, the choice is between the fast track and the multi-track. Faced with most unlawful eviction claims, the court would think that this is going to be a one-day case unless there's some compelling reason that it should go on to the multi-track. We would want to consider carefully whether that really is the case or whether it should be on the multi-track. We want to consider how many witnesses are likely and what the complexity of the issues are. It's not uncommon in unlawful eviction cases to come across the landlord who disputes everything and makes large numbers of counter allegations. That would need time. If it's multi-track, just remember the cost budgeting rules will apply unless the court dispenses with them. So you need to consider there would in reality need to be an order for a cost and case management hearing, and you'd need to comply with the time limit by getting a cost budget 21 days before that. Just briefly before I move on to damages, other directions: standard disclosure, make sure that's not overlooked. Expert evidence, you need to ask yourself whether there's anything that needs to be proved by you by way of medical evidence. And if you are relying on the value of the property, so if you are bringing a Section 27 Housing Act 1988 claim, you will need expert valuation evidence, and you'll need a direction for that expert evidence. This is the last point I just wanted to mention in relation to procedure, which is witness statements. I just want to strongly recommend, especially considering these cases where you have counter allegations of all sorts of things made by a landlord, it's very helpful to have a schedule where you have all the allegations, the counter allegations, and what your pleaded cases are, and then put next to that what the evidence that you have is going to be. I would suggest that should include all the heads of loss, which I'll go on to. I'd also just remind you of the ordinary rules of witness statements, which judges may well throw back in your face if they're not complied with. A witness statement should be in the witness's own words, and that means it's also a requirement of the rules that if the witness's own language is not English, the original witness statement should be in that language, and then it should be a translated version. That's something which until recently you very rarely saw. Follow a chronological sequence. Don't include duplicates of other documents that will be in a trial bundle, whether that's orders, other witness statements, things which have been exhibited to pleadings, or the pleadings themselves. None of that needs to be included. And if there's an exhibit, it's much better to just have one sequence of documents in chronological order with an index at the front, so that someone can read through it in that way. So I'll move on to put here as remedies, because in the light of the cases about general damages, you need to consider an order for reinstatement. So the four heads: general damages, special damages, aggravated damages, exemplary damages, and I'll come deal quickly with reinstatement at the end. In relation to general damages, the key point to remember is damages for mental distress are not available for breach of contract, so you need only for torts. So you need to plead the torts: trespass to land, trespass to goods, trespass to the person, any other tort that this is relevant. The case for that is Watson Morrow. The basis for the significant part of our damages in these kinds of cases is damages usually for trespass, and that is, as explained in the case of Smith and Carn at paragraph 45, that the tenant can have damages for the anxiety, inconvenience and mental stress involved in the loss of what was the tenant's home. So the question of how much, I think we're all familiar with the fact that we look at nightly rates, and that there are a wide range of cases before Smith and Carn going between £100 and £300 a night. So that was referred to in the case of Smith and Carn. This is the leading Court of Appeal case from 2018, and it's fairly clear that they were said to be not strict precedents, but reflective of the value placed by courts on the factors of inconvenience and anxiety and stress of losing a home. And that the Court of Appeal there confirmed the award of £130 a night. So that's good. That's a good basis to say to that this is the range, subject of course, and as time goes on, more subject to increase for inflation. But that is the range that we should be looking at for a nightly rate. I've included here what I have found by way of cases since the case of Smith and Carn, which I guess you would expect. There seem to be less rewards for the cases of single men. So the first case in Sulaco is a case of single man awarded £125 a night, but for a long period of 202 days. The Vada and Vada case, it's a very large amount, but actually breaks down to £94 a night. And the case of Albu, Swallow and Regency, now this is a decision by His Honour Judge Luber QC in the County Court from February 2019. It then went on to appeal to the High Court, where it was upheld. He awarded in that case £150 per day plus a 10% uplift on the basis of Simmons and Castle. He described the circumstances of Mr. Abu Swalin as a single man with no particular hardship or distress beyond the simple loss of a home. So I guess you can see the £150 as being within the range. Clearly, what that suggests is we are looking to put forward factors which suggest particular hardship and distress beyond the simple loss of a home to increase the amount of damages. That the final case there, Sanchez and Simple Properties, £200 a day awarded to a single woman. That's obviously a more generous approach. Again, what we want to do is address in evidence the factors which make this more difficult for our client, that cause more hardship, more distress. In the current conditions, one thing which may well do that is a greater risk of exposure to the pandemic, but we want to be clear that it is the distress that causes. That is something we need to give evidence about, and in order to get the amount increased on that basis. The other big issue in the case of Smith and Carn is the period is how long you should get damages for. Now, the actual decision from Lord Justice Patton is that a cause of action for damages for trespass continues so long as the right to possession actually subsists. How that was applied in that case is somewhat more problematic. So Ms. Smith was not the tenant. It was her husband who's the tenant who had left. She had a right to occupy under the Family Law Act. After she was evicted, she obtained an order for reinstatement, but then when the property was relet, nothing further was done to pursue that order to obtain reinstatement. And so the fixed term of the tenancy then came to an end on the 30th of June. And it's when that fixed term of 2015 in this case, is when that fixed term of the tenancy came to an end that the Court of Appeal decided that the period of damages stopped, because it decided that her right to possession in that case had stopped at that point because there wasn't something there that could trigger the periodic tenancy to arise. Excuse me, I realise the typo is obviously under Section 5 of the Housing Act 1988, not 1986, but it's the ordinary statutory period of tenancy which arises at the end of a fixed term assured tenancy. That didn't happen in her case, but that hinged on the fact that she had not pursued reinstatement. I would suggest in the ordinary case where we would be pursuing reinstatement until it becomes impossible, what the effect of what the Court of Appeal accepted is that it is not only, as it were, until the expiry of a notice seeking possession, but it would also include at least the time it would take to bring proceedings and for an order to actually be enforced. That would be therefore including extended notice periods that were applicable, including the time that would now take to get that, because the right to possession would end at the point where somebody was actually evicted by a bailiff. That is the legal position in relation to assured tenancies and secure tenancies, and that is what we would want to argue until unless something else is decided. Turning to special damages obviously are damages awarded for direct financial loss. And the key points that we need to bear in mind: we have a burden of establishing a loss. That means proving the existence of the item, its condition at the point it was lost, and therefore its value. We need to therefore prove whatever loss or damage it was, and the value of that. The value of it will be the cost of repair, replacement, depending on whether it's damaged or lost. And we need to prove that. If we're saying it had to be replaced, we need to prove why that was reasonable. If we're saying that it couldn't be replaced second-hand, it had to be replaced new, we need to prove that. So these are all matters on which the client needs to give evidence. And it's obviously in our client's interest to prepare the best evidence they can as soon as they can before months go, and it's more difficult to get to remember information. Just finally, financial loss could include other things, and I use the example of the loss of work due to the destruction of a computer, essential work, extra cost of takeaway food. Those things need to be borne in mind, but the same principle applies, that we need to prove them. So moving on to the other sort of heads of damages, aggravated damages, the key point is these are compensatory damages. So they reflect aggravating features of the defendant's conduct. That's aggravated in terms of what the defendant did or the effect on our clients. They are not available in breach of contract. Again, we need to put forward evidence that shows these aggravating factors. That's the matter to go in the witness statement. I have referred there to the usual authority, Drain and Evangelo, which goes back to 1978, upholding aggravated damages in unlawful eviction cases. They're obviously very, very common. It seems rather strange that if we updated the Evangelo figure, it would be 7,300, and that may be something that, if we are actually pursuing these in court, is something we might want to argue about. But unfortunately, there doesn't seem to be much authority, or there doesn't seem to be many examples of anything like that figure being awarded. And looking through the recent cases, figures of around £2,000 seem to be just more common. The thing, aggravated damages should not be confused with its exemplary damages. They have the opposite nature. These are to punish the defendant, essentially on the basis that it's an increase in damages on the basis that there's some feature which means that the other damages are not enough. These are again awarded for tort, not breach of contract. I apologise for the typo there. The principle which is relevant to us, there are three bases on which they can be awarded under the case of Rooks and Barnard, and the principle in that case. The ones which are relevant to us are oppressive conduct, and where the defendant's conduct is calculated to make a profit. Obviously, we want to put in to cover that by means of evidence. An interesting recent case is one I mentioned earlier in relation to the general damages award. His Andres Luber in the Abu Swaling case awarded £4,000 on the basis that the eviction was a criminal offence and the landlord had sought to make a profit. I would suggest that the feature that an eviction was a criminal offence would probably be true of many, many of the cases that we would see, and this may well be usefully used to try to increase exemplary damages awards. So I've just briefly add some things to the to what was been said earlier about Section 27 of the Housing Act 1988 and claims in relation to that. The damages under that heading follow this formula of the difference in the landlord's interests subject to the tenant's interests and without it. So that formula requires valuation evidence, and there are valuation assumptions in Section 28, which will need to be in the instructions to the valuer, because the valuation needs to be clearly made on those assumptions. The reality is that for many short tenancy cases, if you can get a number of nights at £150 or £200 a night, the value of that compared to what this formula would lead to means that you're not going to want to pursue it. That said, worth checking in any case, and worth making sure that you've got a clear notion of the reason why you rejected it. The other point to bear in mind is, even when you do seek it, if you're still seeking reinstatement at trial, then you're going to need to choose between your Section 27 claim and your reinstatement claim, because you can't have both. And the authority for that is the case of Wandsworth and Ossipon from 1999. The final slide is in relation to the issue of reinstatement. So following Smith and Calm, which has introduced really quite a new way of thinking about the effect of pursuing reinstatement or not doing so, there must be a presumption that you will pursue reinstatement at the interim stage and also in a final order. In Smith and Khan, a failure to take steps to enforce an interim order for reinstatement was taken to mean that to be an election not to pursue it. So before you do that, you will need to be clear about the implications of that with your client. So you may well need to seek advice about what you do in relation to that. Enforcement may mean committal proceedings, but if the property has been relet, it may well also mean separate proceedings against a new occupier, which can raise some complex issues, and you will clearly need to seek advice before pursuing those. So thank you very much for listening to me.
Brilliant. Thanks so much, Adrian. I see we have a few questions, and so I'll dive straight in. Sebastian asks, the good thing about these cases is the likelihood of good damages and costs. The bad thing is enforcing those orders against rogue private landlords. Any tips on finding what property they own so you can put a charging order against it? Apart from summoning them to give the court an account of their assets, which requires personal service, often they are very hard to serve and do not own the demised premises. Thank you. Either panelists want to deal with that question?
I have had cases where there's been an inquiry agent instructed under legal aid to do kind of a search of in a particular case. It was in relation to what other property they might own or have a name against, because they may not, even if they may not own the property. If they do, there might not be much equity in it, and that's something you won't know till later on. So it is good to look to see if they. I think it is worth an inquiry agent at an early stage, because of course also under legal aid, you have to have some chance of recovering the damages. Otherwise, there isn't much point in pursuing it.
Can I just add to that? The person who asked this may already have thought of this, but the tenancy relation officers may also have access to, they may well come across rogue landlords they may also be able to do the kinds of the kinds of credit referencing and searching that that inquiry agents would do, and they also have contacts with other people within, because rogue landlords will often come to local authorities' attention through environmental health concerns or other things, and so that may also add something.
Thanks. Julia Wheeler asks, trespass to goods, regarding trespass to goods conversion, in a particulars of claim when drafting, would you refer to Torts Interference with Good Act 1977, or just say claiming trespass to goods? Is there something different that the Act brings in that would need to demonstrate in a particulars of claim?
The Act has specific remedies. For example, you can claim for return of the goods or the value of the goods specifically. It doesn't add a huge amount, I don't think, but I think it's always worth putting it in. It's there as a remedy, and there's no reason not to, in a way. Although I would say yes.
Thank you. Paul Barr asks, so in regards of piercing the corporate veil, can this be undertaken against a company director if they sanctioned an illegal eviction undertaken by a third party rather than directly themselves?
I would say yes, because they're instigating the tort. They're using an agent to do it on their behalf. I think the problem is going to be proof, because obviously, unless you may well have a situation where the tort proof is that actual person did it, said I didn't do it, and so where you can, and then the landlord wasn't there or the director wasn't there, you're going to have a big hill to climb with a lot of inferences to establish facts upon which that person. And I'm not saying it's not possible, but I would have to say that if you have another person involved also who you think who's directly involved, who you believe has assets, then it may be easier to go down that route than something which might be slightly speculative. In which case, you will have costs issues to comply with, to think about. I think it's I think as Adrian said before, just putting down anybody and everybody who might have a connection is not a good idea. But as he says, if you get more evidence that they were involved in instigating it, then yes, that can be considered. But I would definitely take advice on that at the time.
Mark at markpritchard.co.uk asks or says, I have come across a few worrying reports during the pandemic of landlords and licensors destroying a person's property, sometimes using the virus as an excuse. This has often involved homeless persons who have been accommodated in hotels and other forms of temporary accommodation. My question is twofold. Firstly, have there been any amendments to the tort/involuntary bailment rules under any of the coronavirus legislation? And secondly, might any potential defences arise in this context where the landlord or licensor basically says, we had to take this action, we had to safeguard ourselves from the possibility of infection, it was reasonable in all the circumstances, etc. Thanks.
Well, I mean, Catherine, do you know an answer to that, or?
I don't know if there's been any changes in relation to any regulations. I don't believe there have, but I might be wrong about that. But what I would say is that it's if that's going to happen, if people are going to be destroying people's goods for a specific reason, then they're going to first of all have to warn them that's what they might be doing. They're going to then have to have other avenues for destruction. If, for example, they know whether the person whose goods there are has gone to, they should, I believe, make efforts to contact them, find them, and at least have them collected if they're not going to return those goods. So I would be very wary of somebody who said that they have a right to do this because of COVID.
I'm saying that I'm not aware of those, and I would before accepting that either there had been a rule which permitted what had been done, or there was some further defence arising from that, I would take the assumption that there probably isn't, and then wanted to research carefully to see whether there was. But I'm not aware of it.
Olusegun Ajayi asks, during the national lockdown and restriction to eviction during those periods, how would Smith and Can apply where considering the amount of days to claim compensation for unlawful eviction?
Well, I was sort of trying to say that I think that you would want to argue that what Smith and Can requires is to look at the actual circumstances as to how long it would take a landlord to end the right to possession. So you would want to add to the further time that it now requires to obtain a possession order, further time for notice, further time for the possession order, further time to enforce. All of that should be added on. Now, it may be that there will be a case that decides against that, but until there is such an authority, I think that's what you'd want to argue for tenants. Although you'd have to accept that that there's potential doubt with, and when you're advising a client and negotiating.
Now we've come to the end of the questions, but I note that someone has posted something in the chat. We're also coming to the end of the time we'd allocated for this event, so perhaps this can be the last contribution. From Ronald Daly, it says, this is quite a long one, I'll barrel through it. Regarding the statement of value to be entered on the claim form, I wrote the following in an email to the court, and then the following is quoted: having now more carefully considered the requirements of CPR 16.3, we realised that the statement of value that should have been entered on the claim form originally is, quote, that the claimant cannot say how much is likely to be recovered, end quote. The reason for this is that the value of the claim largely depended on how the defendants responded to the claim. It also depended upon other contingencies which were unknowable at the time the claim was issued. For example, how long it would take the claimant to secure alternative accommodation if no injunction for re-entry was made, or if the defendants did not comply with such an injunction. The primary remedy sought by the claimant were injunctions requiring the defendants to readmit her to her accommodation and to return her belongings to her. The court issued such injunctions within days of the claim being issued. Had those injunctions been complied with immediately, the claim would be worth considerably less than £10,000. Discuss.
I can see the rule that Ronald's referring to, although I suggest that may well lead to problems. It seems to me that the correct approach to this is if a court makes an injunction on the basis that it's going to be complied with, and therefore it's perfectly legitimate to put your statement of value on the basis that you're making an application for an injunction and that the party who's enjoined will comply with it. As and when the value of the claim can clearly changes, so for example, it's not being complied with, then you can revisit what fee you should have paid. But the purpose of the real thing here is that you're supposed to be paying a fee which properly reflects the claim that you're trying to make. But if you're trying to get if you're asking for an injunction, then the claim you're making is that the defendant complies with that.
Brilliant. Thank you very much to both panelists, and thank you to everyone who's joined us this evening. I hope you do have a pleasant evening.